Good morning, everybody, and welcome to today's presentation by Bhatia Perry. Our presentation this morning is on the Personal Property Securities Act, and in particular, the treatment of circulating assets and what follows grantor insolvency. I'm David Crease. I'm a commercial litigation specialist, and within that discipline, a lot of my work involves insolvency and property litigation. I'm joined today by my partner from our corporate and commercial team, Norman Donato, who has a particular interest, skill and experience in banking and finance. Before we start, I should acknowledge the Gadigal people of the Eora Nation, the traditional custodians of the land from which we're broadcasting, and pay my respects to the elders past, present and emerging. Now, just at the outset, I'll just go over a couple of items so that you know how to participate in today's event. So you'll have the opportunity to send through questions at any time during the presentation by using the control panel, and we'll endeavour to answer your questions at the end of the webinar. If we don't get time, we'll certainly answer them by email following the webinar anyway, but please pop those questions into the chat box. You'll also receive a copy of the slides and the recording after the event, and a short survey. If you could fill that out at the conclusion of the presentation or after the presentation, we would very much appreciate it. So without further ado, as they say, we'll start our webinar, and I'll hand you over to Norman.
Hi, David. Thanks, David, for that introduction. Welcome, everyone. Today, I'd like to sort of have a look at this concept of circulating security interest, which was introduced by the Personal Property Securities Act to replace, or was intended to replace, the concept of the floating charge over personal property. I want to look at it in the context of how that concept applies in practice under the PPSA and the Corporations Act, and its implications on the impact in relation to priority of payments to various creditors of the company in different situations. When the PPSA was introduced in January 2012, it was heralded as a radical change to the definition of a security interest by abandoning the description of the security interest by reference to the form of the security and replacing it with a functional definition focusing on the substance rather than the form of a particular arrangement. Prior to the introduction of the PPSA, we were all familiar with the concept of a floating charge. As we all know, commercial businesses trade goods and services, and in order to allow that trading to occur, the law recognised the form of security that provided a creditor with a security interest in those trading assets that allowed the business to trade those assets so the purchaser could acquire them free of the creditor's security interest, yet protecting the secured creditor in certain circumstances, such as when a default occurred. The form of that security was known, as I said, mentioned, as a floating charge. But the floating charge was known for its characteristics or form rather than the type of assets that were captured by it. In fact, it was known for the fact that it hovered and then attached to assets. So how could a creditor have an interest in an asset and the company and sell that to someone free of that interest? As I said, it laid in the nature of the security interest rather than the property. The floating charge was something that the law said remained dormant until either the company committed a default or ceased to be a going concern. Until one of these events occurred, the security interest didn't attach to any particular asset. When one of those events occurred, the security interest was said to crystallise and attach to a specific asset, conferring priority to the secured creditor from that asset over unsecured creditors at the time that this crystallisation or attachment process occurred. On the other hand, as you will see from the discussion to follow, that a circulating security interest, which replaces that concept of a floating charge in the Corporations Act, is not defined by its form, but by the assets that it attaches to. It really gets complicated, however, when you go through and see that the assets themselves can, at different point of time, be classified as either circulating assets or non-circulating assets and go from one to the other and back again, or in vice versa. So why is this relevant? The priority of payments that I mentioned earlier, I'm referring to the priority of payment regime set out in sections 433 and 561 of the Corporations Act. Suffice to say that under those priority regimes, where a controller is appointed, whether that be a receiver, an administrator, or a liquidator, the Corporations Act allows certain unsecured creditors to be paid out of certain assets of the company in priority to payments made in relation to a debt owed to a secured creditor. So the concept of a circulating security interest is important. We'll look at those sections in a little more detail shortly, and how the concept of circulating security interest is applied to determine when a priority creditor under those payment regimes is entitled to be paid a debt owed to it in priority to the payment of the debt owed to a secured creditor. Why are we looking at this? As mentioned, the priority payment regime is not new. It previously applied in relation to assets which were the subject of a floating charge. Although the concept of the floating charge under the relevant provisions has been replaced by the concept of a circulating security interest, the policy behind the priority of payments regimes in those sections has not changed. Yet, even though there has been no change to the policy behind these sections, the transition to this new concept of circulating security interest, not surprisingly, has left a few questions unanswered. So we'll look at some cases that have attempted to answer those questions, but also note that there are still some potential issues. All right, let's have a look at section 433, which applies in the case of receiverships. Section 433 of the Corporations Act says, in the case of a company, the receiver or person taking possession or assuming control of the property of the company must pay out of the property coming into his, her, or its hands the following debts or amounts in priority to any payment, in priority to any claim, principal or interest in respect of debentures, and then it lists the priority of payments, insurance proceeds, auditors' fees, and then section 5561, subparagraphs E, G, and H, which relate to employee entitlements. Similarly, section 5561 says that so far as the property of the company available for payment of creditors is concerned, other than secured creditors, is insufficient to meet the payment of any debt referred to in paragraph 5561, the employee entitlements, or any amount in the cost of the winding up, and any amount in respect of which a right in priority is given by section 560. Payment of that debt or amount must be made in priority over the claims of a secured party in relation to circulating security interests created by the company, and may be made accordingly out of any property comprised in or subject to the circulating security interest. So as you can see from section 561, it looks at the nature of the property, not the security interest. Well, actually, it does look that, and I'm about to explain why. And that is because when you look at the definition of what a circulating security interest is, section 51C of the Corporations Act defines it as follows. it is a PPS security interest if the security interest has attached to circulating assets. So the focus is on not the nature of the security, but the assets that it attaches to, and the grantor has title to it. So if we trace through then that definition and work out what are circulating assets, circulating assets are defined in section 340 of the PPSA. And you'll see that there are essentially two classes of assets that are classified as circulating assets. Firstly, there are those listed in subsection 5 of section 340, which have been described as presumed circulating assets. And that is because in certain circumstances, they're not circulating assets. And what are those circumstances? Well, those circumstances are where there has been effective registration and control over those assets. And then the other type of circulating assets are those that the secured party has authorised the grantor to transfer in the ordinary course of business, free from the security interest. So if you have a look at the presumed circulating assets in section 340, you'll see there's a number of them listed there, including currency or cash, inventory, and accounts that are the proceeds of inventory. It's important to note that these are circulating assets, even if the secured party has not consented to their disposal. So unlike the second limb of the test, or the second category of assets that are circulating assets, these are circulating assets irrespective of whether the secured party or creditor has consented to their disposal or being used in trade. So when are circulating assets converted to non-circulating assets, or the presumption falls away that they're circulating assets? And the answer lies in section 340 subsections 2 and 3 of the PPSA. Effectively, those sections say that those presumed assets lose their character as circulating assets if there's an effective registration with respect to the property in relation to the grantor, discloses in accordance with the regulation that the secured party has control of the personal property and the secured party has control. Now, there's some problems with that, which I'll highlight shortly. And there are traps either for secured creditors or administrators of companies who are trying to get hold of more assets within the circulating security interest group to distribute to priority creditors. Control and possession, as I mentioned, are exceptions under, or are methods of which converting or changing the classification of a circulating asset to a non-circulating asset. And it's important to note that control is defined in section 341 of the PPSA, and that in that section, and in dealing with circulating assets, it has a broader definition than it does in other sections of the PPSA. Control under 341 allows a person to claim to have control of an asset according to the ordinary meaning of that term, as well as when it satisfies certain specific tests of control set out under the Act, which relate to control over the different type of assets. And you'll see from the slide that I've mentioned specific tests set out in the PPSA in relation to different types of assets. As I noted before, however, in order to ensure that a circulating asset is not a circulating asset or falls outside of that category, the secured creditor needs to have an effective registration and control of that asset. Otherwise, it will remain a presumed circulating asset, and the security interest over it will be a circulating security interest, which gives rise to the potential that the priority payments regime will apply to any funds derived from those assets. So how can a secured creditor have an effective registration over those assets, disclosing control? There's a bit of a problem, because in practice, most secured creditors that register general security interest register either in the form of an or present and after required property registration with or without exception. And the system does not allow, in relation to that type of registration, the secured creditor to specify control as required by the section in order to have an effective registration. So a secured creditor, or again, if you're on the other side of the fence, looking at whether you can get access to the funds of that, you need to carefully review the form of registration and consider whether or not it satisfies this test to take those assets out of the category of assets considered to be circulating assets. It may require separate registrations or multiple registrations of the security interest. And I'll talk about some potential problems in relation to that shortly. Oops, I think I've gone too far. So under section 340, there is no timing requirement specified for when a secured creditor needs to register a financing statement when it obtains control of an asset. In other words, trying to take it out of the pool of assets available to distribution under circulating assets to priority creditors. If the secured creditor obtains control, say, after the registration of an ORPAC, as I said, careful attention needs to be taken as to whether or not a new financing statement is required. Will the secured creditor need to have different registrations, i.e. registration over those assets that it has control, and specify the nature of the control, and those that it does not? It seems likely. If the secured creditor doesn't have an effective registration after obtaining control at the critical time, that also raises the question of whether or not the PPS security interest vests in the company. Now, that in itself is probably a topic worthy of a seminar for itself, but I'll only bring this up at this stage to draw your attention to the issue and to the risk. So converting circulating assets into non-circulating assets. Another issue arises when a secured creditor, for example, trying to protect its interest in relation to its security interest over circulating assets, tries to convert them into non-circulating assets, and that is whether or not the conversion constitutes or may constitute an unfair preference under section 588 FA if the company goes into liquidation. And again, you know, there's been a lot of law in relation to how that section applies, and the question of whether or not that section can frustrate a secured creditor trying to do that depends upon how and whether or not that provision applies, and the nature of the actions or transaction taken at the time to effect the conversion of the asset. But as most people that play in the area of insolvency and asset protection know timing is everything. If circulating assets are converted into non-circulating assets prior to the relevant time for the classification of the assets, then priority creditors miss out. And that conversion, as I mentioned, can occur in two ways: by the secured creditor taking control of the asset or revoking the authority for any transfer or dealing with that asset. And so there's a number of issues that arise when, a circulating asset is attempted to be converted into a non-circulating asset. You have the competing interests of the secured creditors and the priority creditors and the unsecured creditors, and a number of questions as to determine at what time that security interest arose, and at what time to consider the nature of that security interest. So let's look at a situation, a scenario of a receivership. The courts have held that the relevant date to determine whether the asset is a circulating or non-circulating asset in the case of appointment of receiver is on the date the receiver is appointed. So any circulating asset that came into existence after the appointment of the receiver or was generated through the subsequent efforts of the receiver falls outside of the Section 433 priority payments regime. Now, again, when considering, property of the company, it's important to remember that with the introduction of PPSA, property of the company could also include assets which are subject to a retention of title if the security interest in the property vests in the company because of the operation of Section 267 or 267A of the Personal Property, which relate to unperfected security interests, and Section 588 FL also, where collateral is not registered in time and the security interest vests in the company. Now, in relation to liquidations, the question was also considered. And prior to a recent New South Wales decision in the Supreme Court in RCR Tomlinson, there was some doubt as to the date when a liquidator would consider or should consider the classification of property for the purposes of determining the nature of the security interest. Justice Black had to consider in that case how to categorise certain assets and when the relevant time for characterisation arose, as mentioned earlier. The issues were important because for several asset classes being considered, the classification of the asset could change post the appointment of the external administrator. The timing of the classification, therefore, could affect the priorities in relation to the distribution of funds in insolvency between employees with outstanding priority entitlements and the secured creditors. If the timing of the classification occurred after the appointment of administrators, then secured creditors could make sure that after the appointment, no non-circulating assets would be used or realised, such as to lead to a circulating asset. As I mentioned, a circulating asset would be cash, and converting some of the assets into cash would convert them into a circulating asset. If that were to occur, then secured creditors could frustrate an administrator or liquidator keeping the business going, and to maximise the opportunity for employees to keep their jobs and the sale proceeds for the benefit of all the creditors. Clearly, that outcome or that scenario would be contrary to the objections of Part 5.4 A of the Corporations Act. So the court held that it would adopt what it described as the snapshot date approach being that the date for classification was the date on which the winding up is taken to have begun under Part 5.6 of the Corporations Act, being the date of the appointment of the administrators. That was the date that the liquidators had to classify whether an asset was a circulating or a non-circulating asset for the purposes of Section 561 of the Corporations Act. Now, as we discussed earlier in relation to receiverships, the approach taken in relation to liquidations is consistent with that approach. If that approach wasn't taken, the court's view was that secured creditors would seek to remove assets from administrators and liquidators' control as soon as possible after their appointment, and seek to prevent the conversion of assets to cash and avert the risk of the assets becoming circulating assets. On the other hand, Black also noted that the PPSA did not intend that secured creditors' positions should be eroded during an external administration period, which could occur if assets that were subject to a non-circulating security interest at the date of appointment became available to meet payments to employees as they were converted into cash and became subject to a circulating security interest. And I'm mindful I've nearly exhausted my 30 minutes before handing over to David, so I'll try and quickly wrap this up. So when you have a look at the replacement of the concept of circulating security interest when it comes to priority of payments, and you compare it to a floating charge, we've seen that the intention of the changes made to the corporate insolvency laws was to maintain the status quo in relation to the priority of payments, and this has been confirmed by various cases, including the case, the Tomlinson case in front of Justice Black, and also High Court decision in relation to Cutter Holt Wood Products in the Commonwealth. However, the replacement of the concept of a floating charge with that of a circulating security interest differs significantly in the way that it operates under the relevant legislation. A secured creditor under the current regime can effectively improve its position by taking steps prior to the appointment of an external administrator to improve its return by converting a circulating security asset into a non-circulating security asset, and therefore falling outside the priority payment regimes in Section 433 and 561 of the Corporations Act. Whereas with a floating charge, it was a floating charge and the asset was subject to that charge. Now, of course, if the secured creditor attempts to do that, as I've mentioned, there may be challenges in relation to whether or not it's an undue preference, or whether the registration of that security interest or a new security interest has been created and has been registered prior to the winding up or liquidation of the company, which then vests the security interest in the company. So whilst the policy has remained as it is, there's a number of challenges, including the ability to effectively register, and no doubt in practice, a lot of decisions need to be taken by secured creditors in relation to the actions they take leading up to a company defaulting and possibly going into liquidation, and determining whether there's sufficient assets to deal with all the creditors of the company. And I'm sure decisions are taken as quickly as possible by secured creditors to ensure that as little assets fall within the pool of circulating security assets and covered by a circulating security interest, where it looks likely that the company is going to go into receivership or liquidation. I'm now at 9:30. I have, for your benefit, listed, there's some more slides there dealing with the Tomlinson case and Justice Black analysis of various assets and why he classified them as either circulating or non-circulating assets. I won't go through that. I'll allow you to do that in your own time. And if you've got any questions, if we have time, we can go through them today, or, you know, I'm happy to have a chat with anyone at another time. It's a complicated sort of area. As I said, you have to trace through multiple definitions and consider different definitions and concepts. And it can be confusing talking about circulating and non-circulating assets, but the significance and the consequences are quite, can be quite drastic. And the cases, including the Tomlinson case, demonstrate that. So I'm mindful I don't want to run David short of time. So what I'll do is I'll wrap up now. But as David said, if there's any questions, we'll deal with that at the end, or as I said, we can talk about that at another time if convenient. And without any further ado, I'll now hand you back to David. Thank you.
Hello again, everybody. Thank you, Norman. Norman will be back with me at the end of the presentation in order to talk about or answer any questions you may have, assuming we have time. So my part of this presentation is really about what happens when you get that letter from a liquidator or an administrator saying they've been appointed, question is, well, what happens then with respect to assets, particularly if you're a creditor, that might be covered under the Personal Property Securities Act? So what I'm going to cover in a little bit more detail is a security review, what happens when a security review is undertaken by an insolvency practitioner, because that's the first thing they're going to do. Secondly, some common actual or potential defects in the registration of security interests to watch out for. Thirdly, some other practical issues encountered, particularly in relation to retention of title clauses. Thirdly, errors that can and cannot be potentially remedied after the commencement of administration or liquidation. And some of these topics will be relevant and draw on things that Norman has already discussed in his exposition. So the big issue here for creditors is that if a security interest under the PPSA is required to be registered, but it's not registered, it's an unperfected security interest, and upon insolvency, that property vests in the insolvent entity, into the grantor. That's pursuant to section 267 of the PPSA. And of course, in reality, when we're talking about the property vesting in the insolvent entity or the grantor, the real rub there is that it means that it's a property available to the insolvency practitioner to either pay the insolvency practitioner's costs and expenses of the insolvency administration, or pay unsecured creditors, or both. So that is the significant issue. What is the insolvency practitioner going to do? Well, the first thing that the insolvency practitioner is going to do is to do a review of the Personal Property Securities Register for registrations against the assets of the insolvent entity. And I should add that the Personal Property Securities Register website actually provides a guide to insolvency practitioners as to how to go about doing this, and there is even a particular report that the insolvency practitioner can generate from the register, which is not available to the general public. What is the insolvency practitioner doing? Well, identifying the assets that might be available to the insolvency practitioner to realise and again pay the insolvency practitioner's costs and expenses of the winding up or the administration, or to distribute to unsecured creditors. And part of that is assessing whether or not some property, even if it is registered on the PPSR, can be challenged because of defects, to which we'll come shortly. And also to identify property that the insolvency practitioner knows of that isn't the subject of registration on the PPSR, so that the insolvency practitioner might again be able to access that property to pay costs and expenses and unsecured creditors. So just a very, very simple example. So motor vehicle floor plan financier, I'm sure most of you are aware of the way these things work. You know that when you travel down Parramatta Road and you see all those cars in the car dealers, the car dealers don't actually own those cars. For the most part, those cars are owned by a finance company, which has them on a what we call a floor plan. And that interest of the finance company is a security interest under the PPSR, which should be registered, and indeed registered against the serial numbers of those cars. Now, if the motor vehicle floor plan financier fails to register its interest, then pursuant to section 267, because it's unperfected, the vehicles vest in the grantor, the debtor, when they go into administration or liquidation, or if it's an individual, which is fairly rare, the individual goes bankrupt, and the insolvency practitioner then can dispose of the motor vehicles and retain the proceeds for the benefit of creditors generally, and also, of course, to pay the insolvency practitioner's costs and expenses of the winding up. So this is why this review is undertaken and is very important. So exactly what is it that the insolvency practitioner is looking at when the review is undertaken? Well, firstly, if there is a registration, whether it's been made correctly under the ACN or the ABN of the grantor. Now, the reason for that is that if you have a trustee, a corporate trustee of a trust, and the grantor is contracting with the financier in its capacity as trustee, then the registration should be against the ABN of the trustee, not against the corporation's ACN. Conversely, if the corporation is contracting, giving the security interest in its own right as a corporate entity, then the registration should be against its ACN, its Australian company number, not against the ABN. And that is a very, very common mistake that holders of security interests make when registering. And if you get it wrong, then the registration is ineffective and the property becomes available to the insolvency practitioner. Second thing is the timing of registration they'll look for, because that's relevant to whether or not the security interest has perfected, whether the security interest is effective against the insolvency practitioner. Thirdly, they look to see whether the registration is of a circulating security interest or a PPSA. Now, Norman has already identified the relevance of whether or not a security is a circulating security interest, and I'll come back to this also later on in my presentation. Mentioned about serial numbers before, so they're looking at serial number registrations, whether or not if it's an asset that's required by the regulations to be described by serial number, whether there's any serial number, and secondly, if there are, whether those serial numbers are correct or incorrect, and lastly, whether there is actually a written security agreement which grants the security interest. Because if there is no written security agreement, then there's no security interest. You can't just register on the PPSA without underlying agreement to grant a security interest. So they're the things that the insolvency practitioner will look at, and the next step, after having undertaken that review, will be to write to the security holder and ask various questions, including asking for provision of copies of the documents that record the grant of the security interest, asking for details of what advances have been made, and so on, so that the insolvency practitioner knows whether or not there is a challenge available. And insolvency practitioners have powers to compel the provision of this information. So it's not a request that can simply be ignored. So let's now just have a look at some of these things in detail. Firstly, the incorrect registration under ACN or ABN. As I've already mentioned, if you use the wrong grantor identifier, then it's both a statutory defect and it's also a seriously misleading defect, which then renders the registration ineffective. And any assets or other rights claimed under that registration will become vested in the insolvent entity, ergo the insolvency practitioner, and be available for application to the claims of unsecured creditors. I mentioned looking at late registration. So assets that are the subject of a security interest have to be registered on the PPSA within certain times, and importantly, with respect to insolvency, they have to be registered before the latest of 6 months before the commencement of the insolvency administration, or 20 days after the security agreement granting the interest came into force. If they're not, then subject to a couple of exceptions, or rather remedial steps that might be able to be taken, they will become vested in the insolvent entity and available to the insolvency practitioner to apply again to the claims of unsecured creditors and other priority creditors, including the insolvency practitioner himself or herself, and that's pursuant to section 588 FL of the Corporations Act. Now, I mentioned also the type of security interest is important. Now, there are at least two aspects of this that are relevant. Firstly, if the security interest has been registered as a PMSI, a purchase money security interest, usually so these are usually things, goods that are sold and the purchase price is not paid immediately. So in other words, and there is a security interest given in those goods effectively to secure their purchase price. So if they're not actually a purchase money security interest, then that will be an ineffective registration. So you look to see whether a PIMSI has been claimed but is not a PIMSI. Secondly, and this goes back to our circulating security assets point, if they are a circulating security asset, then under section 561 of the Corporations Act, the Commonwealth has a right to priority of those assets because if it has paid out under the Fair Entitlements Guarantee legislation to employees who would otherwise miss out on salary and superannuation guarantee payments. That arose, this legislation arose out of a number of insolvencies, high-profile insolvencies, where employees were left wanting and the secured creditor took all the assets. So the fair entitlements guarantee legislation was brought in, but the Commonwealth backed that up with the ability for the Commonwealth to recoup that money out of the proceeds of sale of circulating assets. The rider is that it's only so far property of a company is available, only so far as the property of a company available for payment of creditors other than secured creditors is insufficient to meet payment of any amount for which the employees would otherwise have priority under Section 556 of the Act, which is the priority provision. So, in other words, that means that if there are assets available that are not secured, then those assets have to be looked at first by the insolvency practitioner, and only if there aren't such assets available or insufficient assets available that aren't already the subject of a security, then the circulating security assets can be accessed, which often leads to some pretty arguments about whether or not there are sufficient assets available. And it's, again, as Norman mentioned, timing is everything, because you may have the situation where the circulating assets or the assets that are subject to the circulating security interest are obvious and are there and are available to be realised, but the other property, the property that's not the subject of a security, might not have been realised and might not be available to be realised. So, for example, there may be unfair preference claims or uncommercial transaction claims that are available to the liquidator that might produce funds which can be used priority creditors, but haven't at the time. And so there's some debate and some negotiation between the insolvency practitioner and the holder of a circulating security interest as to whether or not those assets should be available. And the third thing is as a result of the principles that were confirmed in the case of Re-Universal Distributing Company Limited, which is that if the insolvency practitioner realises the assets which are the subject of a circulating security interest, then the insolvency practitioner is entitled to take his or her costs and expenses of that realisation, or indeed the preservation of those assets, out of the proceeds of sale before they are paid to the secured creditor. Effectively, what the principle says is, well, if the insolvency practitioner has done the work, then the insolvency practitioner ought to be rewarded for doing that work, and the secured creditor doesn't get a free ride on the back of the insolvency practitioner. The next thing is serial number errors. So I mentioned that the insolvency practitioner is going to be looking at assets that are required to be registered by serial number, looking to see whether there is serial number registration. If there's not, it's ineffective, but also looking to see whether or not those serial numbers have been correctly recorded on the register. Again, because if they haven't been correctly recorded on the register, then again, registration is ineffective and those assets are available to the insolvency practitioner to realise for the benefit of priority creditors, as in unsecured creditors, and the costs and expenses of the winding up. And again, as I mentioned, often these things are motor vehicles. There are other things that need to be registered by serial number, and that category can, of course, be added to as things change, as society changes. One thing that was mentioned to me, indeed only yesterday, by a banking lawyer was the question of whether cryptocurrency might end up being the subject of serial number registration. Cryptocurrency is currently used as security. It's an asset over which security can be granted. Probably falls within the intangible property bucket under the PPSA. And so that's something that might in the future be added to the list of assets that are required to be registered by serial number. But I guess that's a watch this space exercise. So they're the things that the insolvency practitioner is looking for, and the reasons that the insolvency practitioner is looking at those things. Now, these aren't the only issues that arise once an insolvency practitioner has been appointed. So, just a couple of those things we might have a look at now. So, preferences. Now, Norman mentioned unfair preferences in the context of converting a circulating security to a non-circulating security, to a fixed security. So what is a preference? Just a quick recap. So a preference is a transaction, and a transaction is a very wide term. It's usually a payment by the insolvent company to a creditor, and the creditor receives that payment, and by receiving that payment, effectively it gets back more in the dollar of its debt than other unsecured creditors. And the reason it's called an unfair preference is because the policy of the legislation is that unsecured creditors should receive a proportionate sum in the event of insolvency, and no one creditor should get more of its debt, a larger percentage of its debt than any other creditor. Now, there are some rules around that, and the first and perhaps most important one is that we're only looking at payments that are made within 6 months of the commencement of the insolvency administration. So payments outside, or transactions outside that time, aren't relevant. We're only looking to those within the last 6 months before the company falls over. And there are some defences that are available to a creditor, such as that the creditor had no reasonable person in the creditor's position suspected that the insolvent entity was in fact insolvent, that the debtor was in trouble. That's often a pretty hard one to establish for creditors, because usually they've been, the whole reason they've been paid is because they've been pressing the insolvent entity hard to get that debt, and often creditors in that position think it's a rather the fact that the insolvency practitioner can ask them to disgorge those payments is the unfair part after they've taken such pains to try and get that debt paid. Nonetheless, that's the policy of the legislation. Now, the issue though is that the payment must be in respect of an unsecured debt, not a secure debt. If it's secure debt, then it's not a problem. And the area where this often becomes an issue is in the area of retention of title security. So as I'm sure we know, retention of title, that's a position whereby there is an agreement between the usually the vendor of the goods, of the widgets, as it may be, that says, okay, you don't have to pay me up front for these goods, but I am, you've got a 30-day terms or 60-day terms or whatever, but until I get paid, the title in those goods remains with me, and not only the title in the goods, but also the title to any proceeds of the sale of those goods until I actually get paid. Now, under the PPSA, that kind of arrangement is a security interest. So the question arises as to whether or not when the vendor of the goods, so the grantor of the security interest, gets paid, is that payment of a secured or an unsecured debt? Now, the the case of Hussain and CSR Building Products, which was a decision of the Federal Court at first instance, so it was a single judge of the Federal Court. In fact, it was Justice Edelman, who's now sitting on the High Court. He said, well, it won't be an unfair preference because it is a secured debt and it doesn't matter for the purposes of the Corporations Act whether the security interest has been perfected by registration on the PPSR. Now, the reasons that Justice Edelman was of this view was, firstly, curiously, it may seem, the Corporations Act doesn't actually define the term unsecured debt, so you've got to look elsewhere and to look and see what secured property means. The common law prior to the PPSA had established that a retention of title clause can be described as a security. And when the Corporations Act was amended in 2010, it was said to make it more consistent with the PPSA. A definition of security interest was provided in order to give context to the interpretation of the term unsecured debt. And indeed, Section 51A says that security interest means a PPSA security interest. And as we know, retention of title clause is specifically a PPSA security interest. And it was said in the second reading speech that the purpose of the amendment would ensure the Corporations Act treats property provided by a supplier on a retention of title basis as secured property. So Justice Edelman took some comfort from that, and also from the fact that there are other provisions in the Corporations Act that treat retention of title clauses as things that secure debts. I should also note that again, under the Corporations Act, there is a definition of PPSA retention of title property, and that only refers to attachment. It doesn't refer to perfection. That's Section 51 capital F. So Justice Edelman held that whether or not a retention of title security interest has been registered on the PPSR, it means that that debt is secured, and so doesn't constitute an unfair preference. However, that's only part of the issue that arises, because under Section 588FA, a debt is taken to be only taken to be a secured debt to the extent that the value of the security equals the amount of the debt. So how do you value the security at the time the payment is made, or value the security for the purpose of working out whether or not the payment that's been made has been secured to that extent? So there was another case. This was the case of Trentfield and HAG Import Corporation. This was actually a district court, Queensland District Court case. It certainly followed Hussain to the extent that Hussain found that it was a secured debt merely by the fact that it was there was a retention of title security interest, but Trentfield said you've got to value the security at the time the payment is made to the creditor. So you've got to try and go back and get evidence of what security there was. And that security, of course, is in terms of the stock and in terms of the proceeds. And if you can't identify either, then there is no security. So it is an unfair preference. That wasn't the same as the approach in Hussain, which said that until the creditor gets paid, there is a trust which exists over the proceeds, and it doesn't matter whether or not the proceeds can't be traced. Nonetheless, that trust isn't extinguished until the creditor gets paid, and at that stage, only the creditor loses title of the goods or the proceeds, and at that stage, there's no transaction, there's no value. So that was her saying. So we're at the end of our allotted period. So I'm sorry we haven't had time for any questions, but if there are any, we can certainly answer them after the presentation, and I'll flick over now to Norman to wrap up.
Thanks, David. There's a lot there, and it's not surprising that probably it feels that there's a lot of information there for our audience to digest, and some tricky issues for them in practice. And as David said, you know, we'd love to sort of have a chat with you if you've got any questions that you would like to send our way offline. I'm sure David and certainly I would be quite happy to talk through some of that. So basically, look, all that leaves for me to do is to thank you all for attending our webinar today. Once you leave the session, you'll receive a short survey, and we would appreciate it if you could provide us with your feedback. You'll also receive a follow-up email with a link to view a recording of today's webinar along with the slides. So on behalf of David and everyone at Bardia Perry, I'd like to thank you for joining us today, and we'd like to sort of see you in future around the traps or at a future seminar. So please have a great day, and as I said, look forward to hearing from you if you have any questions that you'd like to raise. Thank you.
Thank you all.